Hello, everyone, and welcome. Thank you so much for joining us today. My name is Lauren Matuzzo. I'm the Marketing and Support Coordinator here at HeinOnline, and I will be serving as your moderator today. We are very excited to bring you a live panel on our newest publication called Legal Research Unbound. It's our very first comic book. And today's session, we are going to offer you a little behind the scenes look at the inspiration, design, and some key themes from the 4 chapters of this creative project. You'll hear directly from the editor, the illustrator, as well as some legal research experts who are going to share their perspectives on this book. Before we do get started, there's just a couple quick housekeeping notes. Today's session is being recorded, so if just letting you know that we will be sending a recording afterwards, likely within the next 2 days, so you can rewatch this if needed. We do have the Q&A open, so if you do have any questions, please feel free to throw them in as we're going through. We will be leaving about 5 minutes at the end to address any questions you may have. Also, for those of you who stick around to the very end of the presentation, we are offering a 10% discount off the book if you have not yet purchased it. Again, all that information will be in our follow-up email that will be coming within the next few days. So before we dive in, I will let our guest speakers introduce themselves.
I'm Susan Nevelow Mart.
My name is Tom O'Brien.
Julie Krishnaswami.
Nicholas Mignanelli.
Nicholas Stump.
Yasmin Sokkar Harker.
Okay, and what we're going to do is we're going to turn this over to Susan to get us kicked off.
Thank you, Lauren, and thank you to Hein for allowing us all to become comic book characters. We're here today to talk about the theory deficit most legal researchers are forced to suffer. To borrow a trope of Jane Austen's, Lauren, could you put the next slide on? It is a truth universally acknowledged that there is really a lot to know about the complexities of modern legal research tools, and a really small amount of time most researchers get to receive that knowledge. This comic was our response to that deficit, a short and engaging review of theoretical and practical concepts that can easily be used in any level of legal or legal adjacent research instruction, and give attorneys, law students, and other academic researchers the intellectual tools they need to integrate the underlying theories of legal research into their ongoing research practices. So we all worked with Tom O'Brien to adapt 240 pages of our academic papers on these subjects and to illustrate our ideas. And here's Tom.
This was a phenomenal project to work on. I am very different from a lot of the other comics that I've worked on in the past. As Susan says, I was provided with academic papers from our wonderful authors, which I was first tasked with reading, consolidating, and shortening, and converting into comics script. I spent a lot of time speaking with Susan as both author and editor, and the other authors to confirm that I was still getting their core points across and that I had understood their concepts and was presenting them accurately. As part of the scripting process, I cut a lot down and also generated my best to come up with what the images would be to match the text. From there, I moved towards a phase that we call thumbnails. These are very rough drawings, as you can see here, that make sense to basically no one except myself, with numbers written into where word balloons and narration boxes would go that correspond to the written script, that I did send to other people. I don't know if anyone looked at them or understood them, but again, they were just for my purpose. From there, generally, I would break from my very, very rough thumbnails to outlining my panels. And within those panel structures, which were larger and at higher resolution, I did the first phase of drawings called pencils. Because this was primarily done digitally, I was able to combine my pencils and my inks in a lot of places. Then it was a process of actually going through and making sure everything was colored in our black and white process. And then the final phase was adding our text from our original script back in, which required another editorial pass to make sure that everything read smoothly and fit into the spaces appropriately. So there was a little bit more shifting of how things were structured so that they would fit into our art format. But yeah, and so we ended up going from academic papers that were 200 and some odd pages long down to our comic, which is heavily condensed, but I feel still very readable.
Hi, I'm Yasmin. And if you read the book, you will see me, my comic book avatar, pop up throughout the chapters. Because although each chapter stands on its own, I come in as a reminder throughout the book of a theoretical foundation, a theoretical framework that sort of binds all the chapters together, that they're rest on or they're at least aligned with. And that's critical legal information literacy. So what is that? It's a way of consuming information that considers the actual power structures that underlie the knowledge production. We'll move on to the next slide. A little bit more about that. What does it do? What does critical legal information literacy do? Well, it's a way of looking beyond functional approaches to information, like, oh, we have knowledge to get a good job or to be a good citizen, and helps us confront other issues of power, issues of oppression, inequality. It has us sort of look at those existing power structures that are involved in knowledge production, and that in turn helps us develop a sense of agency and like, where do we stand in terms of creating knowledge? And we can go on to the next one. So what are some ways of thinking about critical legal information literacy, of incorporating it into the way we teach and the way we think? As part of the curriculum, we can consider those political, social, economic, and cultural facets of information. We can think of and present information not just as true, false, right or wrong, or even reliable or not reliable, but information is something that's made by people, comes from people, and is made for a specific purpose. And then it also has a real engagement with knowledge production. What questions do we ask each other? What questions do we ask ourselves about how information is shaped? We can think about who creates it. We can think about who provides access to it. We can think about who organizes it. And these are the issues that are run throughout all of these chapters. So I'm going to turn it over to our next chapter.
That would be me. So your questions of creation and organization lead directly to considering the effect of computer biases, which form the landscape your search terms are navigating within and impact the output you receive. The question of who creates the content is a matter of viewpoint bias, authorial bias in treatises and case language, and the inherent bias of the 19th century classification system used by the major legal research platforms. Machine learning, or AI, since it isn't intelligence, I prefer machine learning, imports all of the computer biases and all of the biases both within platform content and resulting from each platform or application's varying content, and adds hallucination to the mix, which means Could I have the next slide, Lauren? How you frame your search is critically important and impact everything that follows. In creating searches, researchers need to know that there's huge variability in results caused by the very different ways that every algorithm interprets search terms, that algorithms aren't stable and will give you different results from 1 hour to the next, that output is also dependent on content, and that the skill of reframing is critical. So situating the researcher as the primary communicator with the black box and learning how to elicit what you want from each type of research tool are critical legal research tools. Algorithmic biases may seem less important in RAG applications, which is retrieval augmented generation. I can never remember what RAG stands for. Could I see the next slide, Lauren? This is an infographic from a Yale review of AI results. When you use a prompt in a RAG system, I don't know if you can see my finger touching that. It incorporates those limitations and problems before you get to the LLM. This infographic shows you that the prompt translates into keywords and uses natural language processing before the documents are received and retrieved and sent to the LLM. So all of the biases that we've been dealing with for so long are incorporated into these legal research systems as well. So each chapter in the comic illustrates critical legal research theory in a different way. And here's Julie to talk about using them in regulatory research.
Hi, my chapter makes the argument that critical theory or critical information theory can inform regulatory research and in turn lead us to use different materials and ask different questions and have new insights about how agencies regulate. So one area is on the formation of the agency or on the agency's origin story that can impact how the agency operates. Questions about the structure of the agency also illuminates how the agency regulates. These questions lead us to different types of materials and leads us to look at regulatory histories and regulatory dockets with fresh eyes. Taking a critical approach to viewing this material allows us to see the power structures and the bureaucracies in agency operations. And it also asks us to consider who is sitting around the regulatory table that might not be visible. We know that there are regulators, but there are lots of other groups, individuals, and entities that aren't often apparent when we look at regulations in the Federal Register or the CFR. So that's what my chapter talks about. Thank you.
Hi, I'm Nicholas Mignanelli, and my chapter focuses on AI broadly and is a lighthearted reminder that, as critical legal information literacy teaches us, legal information is created, organized, and made accessible by people. And as counterintuitive as it may seem, this is also true of legal information organized by algorithm and or created by synthetic text excreting machines, as the computational linguist Emily Bender has called LLM-based chatbots. As the data cartels that control legal information impose upon our students the generative AI tools in which they have invested hundreds of millions of dollars, it is more important than ever to convey the social constructedness of all legal information. In this case, legal information created through an incomprehensible automated process of identifying patterns in large amounts of data, thus transforming the corpus of Anglo-American law into a data set, automating it, and putting stare decisis on steroids in order to hinder law reform and legal creativity. A critical consciousness about legal information, a healthy skepticism about AI hype, and a sense of humor about the corporate entities seeking to maximize profits by commodifying legal information and automating law practice, I think are the first step in mitigating the potential harms that AI tools pose to the justice system. And now I'll turn it over to my friend and mentor, Nick Stump.
Too kind, Nicholas. But I am Nick Stump, and my chapter examines critical legal research methods that can support public interest lawyering and broader efforts towards transformative social change. So I approach this topic through two dimensions in the chapter. So first, I discuss deconstructive methods. So these are methods that help reveal how traditional legal research tools and also modes of legal analysis often channel researchers toward outcomes that reinforce dominant societal interests or maintain the social status quo. Second, I explore what I call reconstructive research methods, approaches that move beyond the traditional legal research regime and open pathways toward more emancipatory forms of legal practice. So this chapter highlights two reconstructive approaches. So the first is a greater reliance on alternative research resources, including more radical interdisciplinary scholarship, as well as law-adjacent authorities, such as just one example, people's agreements emerging from participatory democratic assemblies. And then the second reconstructive mode is a more grassroots and collectivist approach to legal research, such as methods grounded in participatory action research, or PAR. So via such methods as participatory action research, communities directly affected by a legal issue engage as co-participants in the research design and implementation process. And then such communities help democratically shape real-world solutions based on that research. And then finally, the chapter uses the legal regime governing fossil fuel extraction, specifically the practice of mountaintop removal coal mining, as the case study. So the chapter examines how public interest lawyers, social movements, and frontline communities can use critical legal research methods and efforts to end these destructive extractive practices and to effect broader and more emancipatory social change. So thank you, and back to Lauren.